As far as development is concerned, we are no longer talking about growth for the sake of growth, but we are more interested in inclusive growth. And inclusive growth means that we have to bring in the majority of the population within the ambit of growth, both social and economic. So if you examine these two objectives, which is the governance and development, then the judicial system and judicial reforms become extremely critical. But all the indicators today and all the evidence, both anecdotal as well as compiled by many of the international bodies, shows that Pakistan lags very low both on affordability and accessibility to justice as compared to other developing countries. That means that the majority of the population is not able to get their grievances redressed through the existing system. And this is despite the fact that the National Judicial Policy Committee in 2009 had laid down a set of reforms for judiciary in order to improve both the disposal as well as the affordability. But we are now 15 years from that day of that policy, but nothing much has happened as far as the implementation of those reforms are concerned. The courts are therefore clogged with more than 2.5 to 2.6 million cases, mostly at the district level. And the strength of our superior courts, the courts of the High Court as well as the Supreme Court, is not commensurate with the workload which is assigned to them. There is a shortage of the judges at that level. So the first point I would like to submit is that we have to increase the capacity of our courts in order to tackle the workload. But the more important part is the procedures, which are too convoluted, and some of these procedures are 1.5 century old, while the Britain has gone through a lot of modifications in both the civil as well as the criminal procedure code. We are still stuck with the same laws. So unless we also go through simplifying our procedures and making them more user-friendly, both in the terms of the timing as well as in terms of expeditious disposal, then we will have a difficulty. And the third point I would like to emphasize is the capacity. The commercial laws, the contract laws, the taxation laws, the banking laws are becoming quite complex with the passage of time. And if you are only trained in two major areas of legal training, which is the civil and criminal, I do not think you can do justice to these very specialized fields in which you have to exert both your judgment as well as grasp with the complexities of the problems. So there's a need for completely revamping our legal education right from the college and university days. And the fourth problem, in my view, is the coordination. Of course, we have a constitutional separation between the government, executive branch, the parliament, and the judiciary. But as some of the honorable judges pointed out, a lot of problems arise because of the ambiguity in the law drafted by the parliament or by interpretation which is contradictory in one law to another law, or there are loopholes which are subject to various interpretations, and therefore there is a need for coordination as far as the judicial reforms and the drafting of law is concerned. So the first, and second, third, and fourth problems are the backbone of this whole problem we are facing today as far as the congestion of our courts is concerned. So what is the way out? In 2002, local government ordinance, we inserted the provision for masalati committees at each union council. There are a lot of petty disputes, and I remember when I was growing up, my father was a lawyer, there was a small causes court in Sindh where small disputes were adjudicated by the small causes court. So on the same pattern, these masalati committee with one neutral person was appointed to listen to both the parties and give their verdict as far as that dispute is concerned. That would have reduced a lot of workload on new institution of cases before the courts. But unfortunately, that law was repealed in 2009. And since then, you know what is happening to the local governments. The local governments have not been able to assert themselves or revive themselves. So now we have this 2014 mediation law and the rules, and there is now a new arbitration law which was discussed yesterday in Lahore. So we have the tools and the instruments which are available, and we have to work all together. So the center is an attempt by IBA in order to work with the reputed centers like Singapore, New York, and the UK to train the people in the practice of mediation, do research and analytical work, and have panels of mediators who can help. And we would do this in close coordination with the entire judicial fraternity. We cannot do it on our own. And this particular center, I hope, will be replicated elsewhere because we can act as the benchmark, as a role model for other institutions, because we need so many centers all over the country if this has to take some shape and take some, effect. I'm very grateful to the members of the judiciary, both retired as well as the current one, who have themselves taken on the responsibility of promoting mediation and alternate dispute resolution, and my gratitude and thanks to all of you. And I hope that this small group of very conscientious and committed judges will expand in future so that this mandated mediation becomes a part of the whole process, and we have therefore a reduction in the institution and the disposal of new judges. I don't want to take much of your time, but I welcome you once again, and I look forward to the learned discourse and the discussion of this afternoon from the experts who are present here. Thank you very much.